Do you want an attorney, Mr. Grigsby?
No, sir.
I didn't think so.
I'm not, excuse me, I'm not, again, I'm in special appearance of Contra Grigsby, and no.
Well, I need Contra Grigsby. Grigsby. So whoever, if you're not Contra Grigsby, then we're gonna put a warrant out. We're gonna put a warrant out for your arrest.
Well, I'm in special appearance of Contra Grigsby, and whatever.
Right, so I have Contra Grigsby.
Like I said, I'm in special appearance of Contra Grigsby, and I do not need an attorney.
Before we jump into today's courtroom chaos, buckle up because we've got two very different defendants and one thing in common: a complete misunderstanding of how the legal system actually works. First, we're heading to Michigan, where a self-proclaimed sovereign citizen attempts to explain why he's appearing in court on behalf of ... himself. If that sounds confusing, that's because it is. What starts as a routine hearing quickly turns into a crash course in courtroom logic, with the judge trying to figure out whether the man standing in front of him is actually claiming not to be the defendant whose case is on the docket. But that's only the appetizer. Our second case takes us into a much longer and more complicated dispute involving a suspended driver's license, an ignition interlock company, multiple attorneys, and a defendant who believes everyone from the court to the licensing authorities is conspiring against him. The judge repeatedly tries to explain the difference between a closed criminal case and ongoing licensing requirements. But frustration boils over as accusations start flying as we watch these hearings unfold. Pay attention to a recurring theme. What happens when someone becomes so convinced they're right that they stop listening to the people trying to help them? Will either defendant manage to make a persuasive argument? Or will these hearings become examples of why legal advice matters more than internet theories? Let's find out.
He do not, whatever he do not need an attorney.
City of Detroit versus Contra Grigsby, case number SP168333921, SP1683393, counts 1 and counts 2. Appearance for the record, please.
And special appearance of Contra Grigsby Jr., Suri Juris and Propria Persona.
That went over my head.
No rights. I do not waive none of my rights.
All right, Woody is today is the date and time set for a pretrial. What do you want to do with these cases?
Should be taking it. First, I want to I have added 2 pieces of documents to the court. I want to put them on a record. And my affidavit of conditional acceptance and my Naturalization Act of 1779 I already had on the record. So
I want to take it. You don't see this phone? All right. Okay, that's on record. What do you want to do with these cases?
I'm fighting.
All right, so you want a trial date?
Yes, sir.
I'm going to give you a jury trial date. Let a jury of his peers determine whether his innocence or guilt. Jury trial date, please. In person. The trial date will be in person.
Jury trial. Can handle this. Can this right be handled in private? I request that this be handled in private.
Away, we're seeing one of the most common sovereign citizen style arguments appear in court. The idea is that there's some legal distinction between the person standing before the judge and the name written on court documents. That courts across the country have heard variations of these arguments countless times, and they simply don't carry documents. The moment interesting isn't just the claim itself, it's how quickly the judge cuts through the confusion and focuses on the practical issue at hand. Courts operate on facts, jurisdiction, and procedure, not semantic word games. Notice how the judge keeps steering the conversation back to the actual case rather than getting dragged into a debate about made-up legal theories. That's often the fastest way to handle these situations.
Henry James Matter, 3A0817981.
In your honor, at this point, I would ask the court to allow me to withdraw. Mr. James did file a bar complaint against me. I feel at this point I have a conflict.
Mr. James, go ahead and activate your audio.
Yeah, I have no problem with that.
Well, I have a problem understanding what's going on. So you had previous counsel with SMH. You were then given conflict counsel with Mr. Smith. Are you planning to hire private counsel
No, ma'am.
Are
I
you
didn't
planning-
ask him to withdraw.
yourself?
No, ma'am. I didn't ask him to withdraw. He took it upon himself to do that. I have nothing to do with me.
Did you file a bar complaint against him?
Yes, I did.
Okay, and how do you think that's going to affect your working relationship with your attorney?
He needs to do his job. It was some things that you informed him to do that he did not do. For us getting the evidence for me to prove that I didn't commit this crime that you guys got me charged with. He was supposed to get in touch with Intoxalot. You told me that he don't have to get in touch with Intoxalot. I'm of the belief that's his duty to get in touch with Intoxalot to find out what's going on, and he haven't done his job. He made that decision. It wasn't me this time. He made this decision. I can't afford an attorney. I need another attorney.
Well, we don't have unlimited attorneys to give you. It sounds like you have issues with the attorneys that get assigned to you. And that began.
That's not my fault.
Well, it sounds like it might be something that's related to you more than the attorneys, since you've now gone through 2 attorneys. So, Mr. James, I don't know how we're going to proceed on this case. We don't have unlimited attorneys that are contracted with this court to assign to you.
That's not my fault.
Well,
If you're going to tell the attorneys that they don't have to help me, then what am I going to do? You told me in open court December the 16th that they don't have to do anything for me. I have a 6th Amendment right to be represented by attorneys.